So this leads to an interesting experiment. You know, you get around the holiday Christmas tree or menorah or whatever, the Kwanzaa sticks, I don't know what they are, for whatever particular thing you do. The Festivus pole, you know, get rid of the
yeah.
So you do all this, and you say, kids, I have, you know, adult children you're talking about. I have two ways I can leave an inheritance to you. Which one do you like? Say it this way. I can leave it to you outright, or I can leave it in a trust for you. That's all you say. What do you think they're going to choose? Outright, right?
Mm-hmm.
How do you say, I can leave it to one of two ways for you. I can leave it to you that it's immediately accessible to you, but if you ever get sued, divorced, or sick, you can lose it all. Or I can leave it to you in a way where you can access it and use it for whatever you want. If you ever get divorced, you ever get sick, you ever get sued, the money's protected. Which way would you prefer?
Mm-hmm.
Isn't it interesting? The way we phrase something totally changes the result. And that's what we've done. We described the trust in the second example.
Absolutely. And I was talking about the kind of conversation for the remarriage before, but it's the same thing for a lifetime protected trust. You know, let's say, you know, this is relevant. I have a pretty serious girlfriend, so say my parents leave me assets. If I'm married, do I want to say to her, well, listen, honey, you know, I talked to the lawyer and I'm getting that check written to me, so I'm gonna just put it in my account over here, just in my name, because you know we might like get divorced at some point. You don't want that. You don't want to have that conversation. I'll be sleeping on the couch, or I will be getting divorced.
Yeah, that's right.
Yeah. Disengage. Yeah, never engage.
If it's lifetime protected trust, the conversation is this. Oh, so you know, I got off the phone with the lawyer, and they're doing the rest of mom or dad's estate. And you know, look, what they've actually done is they've set it up with this kind of trust where I can do whatever I want with it. You know, we can use it to go on vacation next year. We can do whatever. But look, if I ever get sued, if I ever have a catastrophic health event, it's protected. Isn't that great? And she says, yeah. I don't mention the divorce.
No, you wouldn't mention that part.
And I'm not lying. I mean, it is protected against, you know, regular lawsuits and catastrophic illness. A divorce is sort of the same legal proceeding where it would be off the table that I just wouldn't happen to mention at that point. But that's what it is. It's making that conversation better for the real world with your beneficiary. And again, that's what we're trying to do here.
So some people say, and logically so, this seems too good to be true. You mean my kids can access the money and still have it protected? Well, certainly under New York law we can do that. There are two provisions of New York law here. One is from the Civil Practice Law and Rules that says that property that is left in trust is protected if the beneficiary didn't create the trust or put the property into it. So that definition, will it protect you against your own creditors for a trust you funded yourself? The answer is no, because it doesn't meet that definition. But if you set it up for the benefit of a spouse or a child, will it protect them? The answer is yes. And
they didn't set it up, you did.
Right,
They didn't put money into it, it was funded with your stuff.
Right, so this is clear on the civil practice law. Under a provision of the estate powers and trust law, a beneficiary can be his or her own trustee and make purely discretionary distributions to him or herself without violating the creditor protection aspects. That's where the person being their own trustee comes into play.
So protected, and
accessible.
They can do what they want with it.
Yep. Now, some people say, well, I really like the idea of a trust, but I really like to protect the assets against my own creditors. Now, we can't protect you against current creditors you have. That would be fraud, both on your part and our part. However, if you don't have creditors currently, and you do some protective planning, and this would require what's known as a self-settled trust established in asset protection states. The most prominent here are Alaska, Delaware, Nevada, and Wyoming. Those are the states that have set up statutory scenarios that you can establish a trust under the law of that state. You don't have to live there or even set foot in that state ever. I set up Wyoming trust quite regularly. I've never been there, nor have my clients. And that trust, properly structured, can protect your assets against your own creditors, and you can be a beneficiary. You can't be your own trustee. So this is a popular tool for like physicians, business owners, and things. People have higher risk than the average person. So it's really a little bit beyond the scope of our program. That's more advanced planning. But I just want to point out to you that there are options for those who really do want to create asset protection vehicles for themselves.
And it's important to understand that when we do trust planning for you, it's not creditor protection. You know, it's protection against perhaps, you know, long-term care costs, nursing homes, that sort of thing. But if you get sued, the stuff we're doing here for you, that's still on the table unless we do some fancy higher-end stuff like this.
So, you know, do all these instruments, do they come out of legislation? How are these
Some
created?
do.
A lot of these instruments created?
Yeah. Some are legislative and statutory.
State and federal?
Almost all state.
Okay.
Trust planning, there is something called the Uniform Trust Code that's been adopted by a number of states. New York is not one of them. That has tried, there's a uniform commissioner of laws that try to get together and create laws that they think should apply pretty much on a national basis. Each state, though, has to adopt them. Even the uniform laws that are often adopted, the legislatures in state will make significant changes. So rarely you'll find a state that totally adopts the uniform law. And New York has adopted some, but not the trust code. We haven't adopted the trust code. So let's talk about IRAs for a second. For a lot of years, there was a controversy whether an inherited IRA, a beneficiary IRA is often called, is protected against the creditors of the beneficiary.
And why would people think that? And now we're not bankruptcy attorneys, but the general idea is that if you do file for bankruptcy, apparently to a large extent, your own retirement accounts are not part of that proceeding. Like you can keep a lot of your retirement.
Yeah, you kind of referred to that in the beginning.
Right.
Maybe.
The IRA was one of the protected.
Right.
Sure.
But what happens if it's an inherited IRA? Well, in June of 2014, so a little more than a year and a half ago, or a little less than a year and a half ago, I should say, the Supreme Court ruled, and this was a 9-0 decision. You don't see too many of those these days at the Supreme Court, in a case called Clark versus Ramaker, that an inherited IRA is not protected from the reach of the beneficiary's creditors.
Right. So if you die and then your kids inherit your IRA, IRAs are different. If you're not familiar with them, what happens is it's not like, you know, if you die with a bank account, your kid just gets that bank account. When you die with an IRA, then your child then just has to start taking distributions out of the IRA. The account, in a weird way, sort of stays in your name. It stays in your name as a deceased person, and your child then just gets distributions out of it.
Yes.
So it's, the whole theme here that we're getting into is how retirement accounts have a lot of different rules. So in that position, the beneficiary of an IRA, Clark v. Ramaker said, you know what, that's not protected like it would be for the person.
And the rationale of the Supreme Court was this. It didn't apply to spouses. A spouse who inherits an IRA does have the same protection because they can do a rollover and defer taking distributions till they turn 70 and a half.
And they can roll it over into their name?
Yes, a spouse can, but no one else can do that. Now, a 40-year-old child who inherits the IRA, they can't defer. Even if the parent hadn't been taking distributions yet, they're 68 when the parent dies, so they haven't reached their minimum distribution age and haven't taken any distributions yet. As soon as that parent dies, the child who inherits has to take a distribution that year. It's a small distribution because it's based on their own life expectancy. But the Supreme Court ruling was, because the law says a child or a beneficiary of any age, could be a 1-year-old grandchild, has to take the distribution out, it can no longer be really considered a retirement vehicle, and therefore it doesn't get the protection of like an ERISA retirement plan. So what's our solution to help protect those assets? Because most people name their spouse as primary and their 2 kids, you know, Joni and Susie, as beneficiaries.
Right. And you can't put a retirement plan into a trust.
Right. When you own it.
You can't change the owner of it to anything. It has to be you individually, otherwise it's a big taxable event, whatever the value of the IRA is, you just get income for the year.
Right. So what attorneys will do, who know what they're doing, will create what's called a standalone retirement plan trust that will act as a contingent, typically a contingent beneficiary, or if you have no spouse, a primary beneficiary of your IRAs and retirement accounts at your death.
So instead of your kids being the direct beneficiary of the account, your kids will each have a separate trust share under this retirement plan trust, which will be the beneficiary under the retirement plan account, and they'll take their distributions through that.
Well, you know, I don't want to take too much time.
Well, let's see if we answer
hold
the
your thought,
question.
yeah. So this slide represents a structure of a typical standalone retirement trust. So we have a guy, Archie, who has $1 million IRA. His wife is Olivia. Archie, once he reaches 70 and a half, has to take requirement minimum distributions based on his life expectancy under the Uniform Life Table. Now he dies. Olivia was named the primary beneficiary. Now, if Olivia was his second spouse and not the parent of the children, probably have a different conversation. We'd probably create a trust for Olivia as a beneficiary. But in this case, let's assume it's a first marriage. She receives it, or she can do what's called the disclaimer. And instead of having their 3 sons, Cooper, Peyton, and Eli, as the individual beneficiaries, what we've done is create a standalone trust with a separate share for Cooper, a separate share for Peyton, and a separate share for Eli. Under this scenario, each of the 3 sons have to take required minimum distributions over their life expectancies. Cooper's the oldest, so he'll have a slightly faster payout requirement. Peyton is the middle child, a little bit less, and then Eli, the youngest, takes even the lower amount over the course of his life. But what happens is it's not paid to them individually in their names, it's rather paid into a trust, so they avoid the negative result of the Clark versus Ramaker case.
Right. They still get the creditor protection. And by the way, they get to keep taking it out by their own life expectancy.
Right.
If the trust doesn't look right, and that's why we do a separate kind of trust for this, you know, someone, you know, they might say, well, why don't, you know, if Archie has a regular revocable living trust, why wouldn't we just name the trust shares of that? And the answer is because retirement plans are so drastically different than every other kind of asset, pretty much. We want to have, look, again, I said we have computers, right? We just want to do a separate document that is tailored specifically to retirement plan rules.
Trying to force the IRAs into a standard revocable trust share for a child is a little bit like doing the square peg in a round hole. It can possibly fit, but not really well. Now, if someone comes to us with a $10,000 IRA, are we going to do this? No, we're not going to do this. Usually, you know, we're saying a couple $100,000 above is probably the break point where it's worth doing this.
What would you do with the 10,000?
Just name the 3 kids individually. You know, so if they're going to inherit $3,000, if they're going bankrupt, not going to be helpful in a trust anyway. Yes.
Do the same rules apply with the 401k?
401k is a little different. We still use this structure for that. The good news is, though, an inherited 401k is protected under a federal ERISA law, but many times people will roll those out into an IRA when they retire. So we don't want to just take the chance that they're going to keep it in the 401k. Maybe it's not the best investment option. So using a standalone trust will apply in either case. Not legally as necessary with the 401k, but the practical effect is the same.